Hi everyone, sorry for the slight delay. Hope you're doing well. For those who don't know me, my name is Sean Coxwell. I'm the CEO and co-founder of Law in Sport. As always with these things, interesting, today is the day for it. We just had a few issues with one of the speakers getting access. There's always a technical problem, which is normally down to something to do with blaming Zoom anyway, not our technical abilities. Look, really delighted to have you with us today. We're expecting 100 or so people to join today's webinar. But before we do, I'll go through some house rules. One, we've got to wait just for a few minutes, just as people are getting themselves.
Actually, just as again, if you haven't joined any of our webinars before, well, first of all, again, thank you for joining us. We've got the chat feature. So one of the things I think that is a very nice thing to do when you're doing this, it's much better to meet in person. But since we're not doing that, if you wanted just to introduce yourself in the chat, say where you're from, if you want to put your LinkedIn connection in, if you want to connect with people, if you do want to build friendships and connections around the sector, then please go for it. I need to come up with a decent prize for whoever's the first one to put their name in, but people normally find that quite useful. If you've got a question you'd like to ask, please use the Q&A feature. That then allows me, as I'm going through doing the moderation, just to make sure at the appropriate moment in time, I can come to the relevant speaker and make sure that we get through as many questions as possible. Brilliant. Max, well done, you. Thank you for being with us. Christopher Flanagan, great to have you with us. Future PhD. But really nice to have you with us. Yeah, so the format of today will be, we're just waiting for one of the speakers to join. We're just having some technical issues with them joining. What will happen is, and if in the next minute or two they can't join, I'll do some scene setting and then we'll come to our first speaker. The plan of today was really, and the intention behind this is that there's a lot going on. There's a lot of developments going to be coming over the next 12 months. Obviously, we've got the Football Governance Act, which has now received royal assent. And here we go. There he is. Trevor, can you hear us?
I can hear you. Can you hear me?
We can hear you, and you're at Twickenham Stadium of all places. So thank you so much. And sorry for the issues. I think we it was an error on our part sending the wrong link to Trevor. So look, thank you everyone for joining us. Trevor, I've just gone through and run through the format. What I'll do, Trevor, I'll just mute you. Whilst I think it's picking up other people, I believe. I can hear some background noise. There we go. That's it. Great. So when you come to speak, Trevor, I'll mute you. I've asked everyone to introduce themselves in the chat so you get to see who's there. What we're going to do, Trevor, I thought the best thing to do is just come to you first of all, if we can, just to set the scene of where we are now. I was just saying that the Football Governance Act has received royal assent. Maybe we can come to you to get your initial thoughts. Then I'll come to Raphael and David. And what we're going to do is pick out, there's a lot going on, but pick out what we think are the most pertinent points. And obviously answer any questions that you have. Trevor, shall I come to you? There we go. We were joking beforehand that Twickenham has great Wi-Fi, but obviously there's some issues with that, right? I think what we do whilst that's getting resolved, as I was saying earlier, so receive royal assent. Next week, the Independent Regulator are holding a consultation with football clubs in which they'll be going through telling them what's going on, what the process is, and particularly on discussing the topics, the three topics that they've gone out for consultation. But to start us off, Raphael, perhaps you can kick us off with what you think is at this moment in time is the most interesting or pertinent area that you're focused in on.
Sure.
Or curious to see.
Thanks very much, Sean. And thanks everybody for coming, and thank you to Law in Sport for having us at this webinar. I'll just very briefly kick off by telling you who I am, since I, unlike some of you, have not put it in the chat. I'm a barrister at 11 KBW. I specialise in regulatory law, and in particular in acting for and against statutory regulators. So, you know, the ICO, the Office of Rail and Road, Ofsted, Ofcom, various other Ofs. Lots of my clients and opponents begin with off. And I'll let you use your imagination to think about whether what they say to me ever ends with off. But that's well, that may be something that we come to later. Obviously, as you mentioned, Sean, the IFR is currently running a couple of consultations, and I think the topics that David and I wanted to say a little bit about relate to issues on which the IFR is currently consulting. One of the things it's currently consulting on is its approach to enforcement and sanction. And so what I thought I might do to kick off is just draw out a few hot topics in relation to how the IFR is going to operate in terms of its enforcement powers. Thanks, Sean. If you could just flip to the next slide, I want to just say something very brief about 4 aspects of that. So that the IFR's investigatory powers, its enforcement process, its sanctions regime, and the mechanisms for challenging its decisions. So if we could flip to the next slide, Sean. Looking at the IFR's investigatory powers, the IFR is now going to have 2 key statutory tools to investigate clubs and indeed other regulated entities. It's got the power to require information by notice from you, and that's a pretty standard regulatory power. That's the sort of power that a lot of regulators have. What's really new here for clubs is the statutory power. And by the way, failing to comply can itself, in some circumstances, lead to sanctions, or even in some circumstances, a criminal offence. And so it's sort of that added level of statutory backing. And the IFR also has this power to appoint an expert reporter on an issue in an investigation. I think that's potentially most likely to be needed in relation to financial analysis. That's really a concept that's been ported over from the financial services regulation context, where sometimes the regulator doesn't have the technical expertise in-house. So those are the key powers, but what are the real issues that clubs need to be thinking about in relation to those? I've drawn out 2 of those. The first, I think, is the balance between informal and formal information gathering. So the IFR has said that it's not going to be an enforcement-led regulator. It's going to work constructively with clubs to address issues before they crystallise. But at the same time, it said in its consultation that it anticipates using its information gathering powers, so these powers on the slide, as a regular complement to requesting information informally. So actually, although there's sort of a high-level indication of a constructive approach, the mood music on the use of these quite robust powers is itself pretty robust. Secondly, the IFR in its consultation seems to be anticipating, I think, some significant early spats over confidentiality. I think it's a really significant point that this is a move for clubs away from regulation by private bodies operating under private law powers. So, if you take the EFL and the Premier League, those are both limited companies exercising powers under contract, to a public body regulated by public law. And inevitably, that's going to bring the regulatory process into the public sphere to a greater degree. And that's notwithstanding that some of the information and documents that are inevitably going to be provided to the IFR, particularly in relation to things like financial sustainability, the onus test that David's going to come on to talk about, and so on, will be acutely confidential and commercially sensitive. And so the IFR is going to have to balance that acute sensitivity with its own duty, a statutory duty, to act as transparently as reasonably possible, reasonably practicable, in fact. So something I think clubs should be thinking about as they engage with the IFR is whether they need a kind of structured process for the IFR giving clubs notice of anything that it intends to publish as part of its regulatory activities, to give them opportunities in a sort of structured forum to make representations about confidentiality, not just when it's providing the information, but when you know what the IFR is actually planning to put out there. And if necessary, apply for injunctive relief to restrain publication. Obviously, you don't want to get into that if you can avoid it. But in regulatory respect with regulators,
yeah, I was going to say, in that, maybe I've preempted what you were going to say, which was, so apologies if I did. But is that what you've seen? You said you work for all the other offs. Is that what you see as common practice in those other regulated sectors?
Yeah, absolutely. So it's really variable how regulators deal with this, but it is not uncommon for regulators to have guidance in place under a publication scheme, publication guidance, transparency guidance, something along those lines, that makes a sort of commitment to where a club has said, where a regulated entity has said something that is being provided is confidential or commercially sensitive, effectively giving them notice of anything that is going to be published before it's published, to give them an opportunity to make representations. And actually on sort of actually going to court over publication of stuff, that happens, or at least is threatened, more than you might think. I think I've been involved in a couple of cases where regulated entities have sought injunctive relief against regulators to stop them publishing something really reputationally damaging before there have been any actual findings of breach. And I've seen a lot more cases than that in which that kind of action has been threatened, and it sort of affects the view that regulators take on publication.
And so, and just to be clear for everyone else, and again, I was joking around this. I was speaking to the experts, and I'm the sort of, I guess, the lowest common denominator, asking sort of obvious questions. So forget again, if anyone wants to ask any questions, please do put it in the Q&A feature, and I'll come to it at the appropriate moment in time. But in terms of this, the consultation phase at the moment, and you've obviously said you've worked with a lot of regulators that have been established. DCMS and now the independent regulator is also saying again they really want to have this constructive, you said, lighter touch approach. But no doubt they also, given that this is going to go, as you say, going to be statutory powers, that they have to make sure that they're thorough enough and accurate enough during this consultation that should they ever need to have those powers, they have them there, not assuming that everyone's just going to be good actors. So how does that balancing that kind of work out in practice, and how important is this consultation phase for all the stakeholders? Because it's not just the clubs themselves, it's the fans as well.
Indeed, I think that's a really good point. I think in terms of what impact the consultation has, what the IFR is now doing is it's consulting on guidance, right? It's consulting on the guidance that it will then have on its website. And that does matter, not least because the IFR, as a statutory regulator, will be under legal duties to comply with its own guidance, at any rate, unless it has good reasons for departing from the guidance. Generally speaking, there's a duty on a public body to comply with its own guidance. And so that means that at this consultation stage, there is a sort of shaping effect on how that balance that you talk about, Sean, is going to be struck between, if you like, the good cop hat and the bad cop hat. At the same time, a lot of that, I think, is going to have to be worked out in practice in the first months and years of the regulatory regime being operated, and it's going to reflect ultimately how the relationships form between the IFR and the regulated entities, and also the sort of strategic direction that the leadership wants to take. A lot in a regulator can be affected by ultimately kind of the way the wind is blowing in terms of the policy steer that people doing enforcement or sort of case management are getting from the leadership.
Thank you.
I don't want to massively overrun
No.
my time, but if we just pop to the next slide and I can sort of zip through this. What I've put on this to sort of give people a sense of a shape of what might be coming is what the enforcement process, according to the IFR, looks like. Right, so you've got an investigation open with an investigation notice. Then you've got that information gathering stage that I was just talking about. And then you've got a warning notice and opportunity to comment for the regulated entity on the findings. You've got a final decision and then any sanction. And so two issues to think about that I wanted to draw out in relation to that. The first, which relates very much, Sean, to what we were just having an exchange about, is the IFR's interest in what it calls a supervisory approach. And I think it's really interesting and important that the IFR has said publicly that it's going to operate a supervisory regime rather than a regime relying on after the event enforcement. What does that actually mean for a regulator? It means the regulator wants to use its powers to prevent breaches rather than using them to remedy breaches that have already happened, right? And actually, statutory regulators are really variable in where they sit on that spectrum from supervisory to after the event. So in the financial regulation space, there's a massive architecture for market supervision. Contrast a lot of safety regulators, contrast the ICO, the data protection regulator, where the regulator really doesn't want to ever dip its hands in the blood, right? They don't want to ever suggest to you that your approach is good enough, because then if it turns out to lead to harm, they want to be able to come and take action against you. So regulated entities can find that after the event approach really frustrating. So in one sense, it's really good for clubs. The IFR is sort of planning to adopt this more supervisory approach, but there's a downside to that too. And that's that this kind of supervision can mean more interference in the regulator, more interference by the regulator, I should say, in the day-to-day, right? Because that's how the regulator keeps you on the straight and narrow. They straight and narrow. They want information, they want engagement, they want contact. And that can be a burden on your legal resource, on your management time, and also on your confidential information. Sure, you know what, Sean? I'll skip talking about commitments because I don't want to grind into anybody else's time, and we should leave plenty of time for questions. I'll just say something about sanctions. So if that doesn't go well, if the enforcement process doesn't go well, and the IFR comes after you with a sanction, then where might that end up? So there are slightly different sanctions for different infringements. I'm not going to get into the detail of all of that. But basically, there are 4 big things on the menu, right? So the first is a censure statement, which is basically the publication of a ticking off on the IFR's website. It's a PR stick for the IFR to wield. Bad day in the press. Then you've got fines, for which I've got a picture of your money floating away from you. But actually, there should be a lot more bills on the slide than that, because depending on the seriousness of the infringement, that fine can be up to 10% of revenue for a club, or for an officer up to 10% of their remuneration. So really, potentially, very significant fines that we're talking about in the most serious cases of infringement. For cases of ongoing breach, one available sanction is the appointment of a skilled person to assist the club in bringing that breach to an end. And the club's then got a duty to cooperate with that person and assist them in their job. And obviously, in terms of management time and autonomy, commercial freedom, that is not something you want to be getting into. And then for the very, very most extreme cases, we're talking about suspension or revocation of your license to operate. And it's worth saying, as is totally standard for regulators, you'll see this in most statutory regulators' guidance, and you'll be familiar with it from existing regulators of clubs as well. The regulators set out sort of multi-step approach for its consideration of sanction. So it starts by considering the seriousness of the breach, by reference to its impact, whether it's deliberate, whether you've cooperated, then considers aggravating or mitigating factors. So aggravation might be concealment of the breach or a lack of cooperation, if you've got previous, a continuation of the breach after the investigation, or mitigation, on the other hand, might be sort of being very transparent, cooperative, bringing it to an end promptly, engaging with fans over the issue. And then finally, it kind of stands back and looks at the proportionality of the sanction that it's ended up with. So there are some new details there of exactly what this regulator can do, but I think a lot of the flavour of that is probably going to be quite familiar from dealing with existing regimes. Sure.
I'm not sure if David, you're going to touch on this, but Stephen Cohen has asked a question: can the IFR effectively regulate in the absence of a chair or and a board? So in this situation, if imagine a whole board has been found to have mislead, as you say, conceal breaches, and then they all have to be removed essentially, or ends up in under a sanction. Is there a situation where, or if there's not an effective functioning board for other reasons, is there is currently proposed, is there an intervention from the IFR?
So I think there are a few different strands to that.
Oh, and he said currently where there is no chair or board. I'm not sure in those situations, but anyway, carry on.
So I think that there are 2 things that one might be getting at there: whether the absence of a chair or board itself would be a breach of any duty under the Act or any licensing condition that's capable of giving rise to enforcement action. And then the second issue would be if there is some other freestanding breach, then in the absence of a chair or the board, can the IFR nevertheless come after you, even if you've not got a chair or a board? The answer to the second question is, I'm sure the IFR can still come after you. The answer to the first question, whether the absence of a chair or a board would constitute itself a breach, pass on that. I can have a think about it while somebody else is talking and come back to it later. Or when David talks, he might know the answer straight away without needing to think about it. I'll just, if you just flip to the last slide, Sean, I'll just say something about challenging the IFR. So at the moment, this is all pretty distant, right? But I'm the barrister in the room, and we love a good fight. So this is the bit that I get really excited about. Two kinds of potential challenge under the Act. The first is reviews. So this is essentially where you ask the IFR itself to look again at a decision that it's already made. And most decisions that it makes are reviewable in that way. And there are some slightly tricksy provisions about when it can decide that it's not going to hold a review even though you've asked for one. But I think the one really hot topic on that is going to be the suspensive effect of these reviews. It's up to the reviewer at the IFR whether it suspends the effect of the IFR's original decision while that review is taking place. And there's not a lot in the statute or the guidance about how the IFR is going to approach that. But actually, in practice, even though the issue doesn't jump off the page when you're reading the statute or the guidance, in practice that can be hugely consequential for regulated entities, right? Because if you've got a decision that someone's unsuitable or there's a sanction or whatever, there's a very big difference in terms of what happens next, both in the club but also in the wider market reputationally, between saying that decision has effect, but we're going off to challenge it, and saying in effect it's provisional, because the IFR has the regulator suspended the effect of it while we go and test whether it's actually right. So that's a really interesting one to engage with the regulator on in the course of this consultation. Second way of challenging is going off then to actually appeal an IFR decision in the tribunal. The sort of interesting issue that I've flagged there is the intensity of the review. So broadly speaking, in this sort of context of certain kinds of decisions, what you're looking at is a kind of judicial review approach. So the same approach as when a Secretary of State or any other public body gets reviewed, which is to say that the tribunal is looking into the legality of the decision, but not looking into its merit. And again, I think clubs will have some familiarity with that from having applied similar types of principles within arbitral proceedings. And ultimately, the big lesson to take from that is that you've got to get it right the first time before the IFR in terms of putting your best foot forward, because you can't have a clean run at it when you go off the tribunal. And with that, I'll hand over and
brilliant. No, thank you. And I've got some follow-on questions, but we're bringing David in. Trevor, I think thank you for being patient and getting it all sorted at your end. But David, we'll come to you, and then Trevor will come to you afterwards with some reflections from your side. David, why don't you want to introduce yourself first, and then thank you for waiting. And can you just introduce yourself, and then what for you is the I think it's the owners and directors and the officers side of things, but over to you.
Okay, thanks, Sean. Hi everyone. So I'm a legal director at Pinsent Masons. I specialise in public law and government. I've got a background that I worked for many years in the UK government, so I'm used to former gamekeeper. I still sometimes advise the gamekeepers in public bodies like this, but also the poachers. And I've been working very much with colleagues in the sports team, like Trevor, who's with us over the last couple of years, advising some of our clients in the football sector on what this new regulator means for them. So the pleasure of getting right stuck into the weeds of this over the last couple of years. I was quite keen to sort of focus in particular on the owner's test, which I think is well worth focusing on today, because it seems to be the IFR's first priority. One of its first acts has been to publish its draft rules and guidance on the owner's test that it will apply when it's considering whether to approve owners as suitable to be owners of clubs. That consultation is out on running. The IFR seems to be in a hurry. It's only allowed a 4-week consultation period, which closes this Monday. And also you get a little bit of a hint of the politics behind what's going on with this. The IFR issued a press release when it launched this, talking about how it wanted to tackle rogue owners in football. So you kind of get a sense of this as one of the IFR's sort of top political priorities. I thought what I might cover briefly was just split in two. One, looking at how the substance of the IFR's owners test, how that differs from the league's owners test that they've been applying to date. And then secondly, I wanted to talk about those elements that are the same, about how I think they may work differently in practice because of the IFR and who it is. So if I talk first about the substantive differences, I think it's fair to say that most of the owners test is the same as what we've seen before. It's been based on the test that is applied by the English Football League and the Premier League in their rules. That does raise an important question that I think a lot of clubs have been asking: is this duplication that's needed? Will the leagues drop their tests? I think we've been hearing indirectly that the English Football League plans to drop its test and leave this as a subject for the IFR to deal with. Haven't been hearing any noises yet about what the Premier League has decided to do, whether it will keep maintaining its own position. If you are going to have two tests running in parallel for ownership of Premier League clubs, are these two regulators going to cooperate with one another? I don't think it's in anyone's interest to have everyone jumping through two sets of hoops needlessly. So I think that's going to be a really important issue to watch, to see how that emerges. I think both to watch and listen to both what the IFR are saying, but also the Premier League. But although much of it is the same, I think there are three important differences in the substance which I'd like to highlight. So the first is the IFR's got a slightly broader definition of who is an owner. So it's not just an owner if your shares in the club carry 10% or more of voting rights. The IFR test in the Football Governance Act is instead based on the rules that apply to companies under the Companies Act 2006. And that also introduces the slightly grey area of persons who have significant influence or control over a club. That's not defined in the Act, and it needs to be defined in guidance from the government. So notably not from the IFR. This is guidance that needs to be published from the government. That hasn't come out yet. But equally, I'm not expecting any surprises on that, because there is guidance on this concept already under the Companies Act 2006. And so what I'd be expecting to see is we're going to see a copy and paste of that guidance from the government, but certainly one to watch there. And whatever the guidance is going to say, it certainly introduces a little bit more of a grey area, but does seem to be a slightly broader definition of owner. Second key difference is that in terms of timing, the IFR's approval process is not an open-ended one. So generally, that approval process for new owners, there will be some back and forth with the regulator, that whether that's legal or IFR, providing documents, more being asked for, more information about this and that. What we have under the Football Governance Act is a cut-off at the end of the period, and if a decision is not made by that point, then the IFR is deemed to have rejected the owner. So it's quite high stakes, this cut-off. The government, again, it's the government decision rather than the IFR, is consulting on what that deadline should be. It's proposing an initial 3 months with the option, the IFR, to extend for an extra 2 months, so 5 months in total. That strikes me as a reasonable period, but what it does mean is, as I said, the stakes are high. It means there's certainly going to be pressure on owners to be prompt, to be transparent, cooperative with the IFR. But equally, I don't think the IFR can be completely relaxed. I think it will face its own pressures through different means. I think it can expect to face legal pressure and also political pressure. The IFR will not want to be seen to be a blocker to what might be seen as good investment in football clubs, and the IFR certainly needs to account for what it does in the political sphere in Parliament.
So no doubt they've got some point of reference as well, though, from the other regulators in terms of what will be required in terms of staffing for this, in terms of to get the sort of, let's say, the the number of clubs, the time it would take. No doubt they're modelling all this out, right? In terms of, so they've got an idea. So it's not going to be that there's just one person causing a blockage, right? There's going to be a slightly more sophisticated than that.
Yeah,
right?
yeah, one would certainly hope so. And I think that kind of goes to the sort of the real world politics of this, is if they did create some blockage by not having enough resources, that would become a massive political issue really very quickly. And it's difficult, I can't see that worst case scenario, because the government would just not stand for that, and nor would Parliament. And then the third substantive difference I wanted to mention is the IFR has been indicating in this draft guidance and rules of supply that it seems to indicate it wants to apply the test just a little bit more strictly than the leagues have to date. And there are some hints on that in the consultation and the guidance. So the IFR has been talking about how it's going to be requesting a bit more detail on the financial plans that owners have for a club, and also some of the factors that it takes into account, some of the negative factors that may count against an owner. So if an owner has a history of non-cooperation with a different regulator, or if that owner has past links to a company that has been in financial distress, those are negative factors that the IFR said it will take into account.
And David, and maybe this might be, again, Trevor, obviously you've been involved in a club as well. So, but I wondered what your views were on the senior management function and the meaning of officer, and does that have any sort of like further implications that maybe clubs should be thinking about quite carefully? I know, obviously, under corporate law, you've got the senior management regime under the Corporate Transparency Act, and there's been developments there anyway. But one wonders, with some of the alleged conduct of and that coming more under the spotlight at the moment within clubs, if that is going to potentially be something that clubs need to pay attention to, particularly in the short term.
Yeah, I mean, so there is a similar test that applies for senior managers, and I've sort of been focusing on the owners. That broadly the same issues arise. The extra issues that apply in relation to those senior managers is how far down the organisation do you go in terms of needing that approval. I think again, a bit of real world context here is that the IFR is, and there's a hint of this in its consultation and the things it said, is it knows it's going to have limited resources. It's not about to start holding up the real world by reviewing everyone. One of the interesting issues is it does have discretion to start reviewing and going back through all 116 clubs and looking at all of their members of staff and current and their current owners if it wants to, but there's no sense that it's planning on doing that. And it's said in relation to owners, it's going to take a targeted approach if it's got realistic intelligence that there is an owner who is causing major problems in terms of the financial sustainability of a club, then it's going to step in. But otherwise, it's looking forward. So it's looking at new appointments, whether that's senior managers or in terms of new owners coming into clubs.
Well, that makes a lot of sense as well in terms of, as you say, that more targeted approach. Great. Sorry, and back over to you, David.
Yeah.
I've got a couple of questions, but
okay, well, I'll just finish off the other stuff I was going to cover, which is sort of about the nature of the IFR, which I think probably goes beyond the owner's test, but I think is interesting to look at it through that lens. And I was going to highlight sort of 3 features of the IFR that I think are really things to watch out for and for clubs to prepare for in terms of developing that relationship with the IFR as their regulator. The first is the IFR is going to have stronger powers in statute to obtain information about owners from clubs, so it can get that from banks, other regulators, law enforcement agencies. So definitely going to be more difficult for an unsuitable owner to hide their past in future. The second is, as we've been hearing from Raphael a minute ago, the IFR has got stronger powers to remove club owners. And in particular, in the context when we're talking about owners, it can force an owner to dispose of their shares or other interests. It can step in, appoint trustees or experts to run a club until those shares have been sold. And it can also issue disqualification to prevent an owner from getting involved in any other club in English football. So that's the second one in terms of stronger powers. And then the third one I talked about earlier is this, and Raphael did as well, this greater transparency that we're going to see around the IFR. It's a public body. It needs to account to Parliament and public. And even in the legal sphere, if it's going to face challenges, those are going to be challenges in open court in the Competition Appeal Tribunal. They won't be the arbitrations behind closed doors that we become accustomed to seeing with the leagues. And I think that really means the IFR is going to be operating partly, it's going to have one foot in the political world. It's going to have fans and politicians. Let's not forget football fans are voters too. Lots of people will have views, trying to tell the IFR what it should need to do. It's going to have these views coming to it left, right, and centre. And I think so that's going to be one thing really important for football clubs. They need to be prepared to handle this sort of wider public, political, and media scrutiny that's going to come with how they engage with the regulator. So maybe looking a little bit more broadly and not just focusing on how do they deal with the regulator themselves, but how do they deal with that wider public relations piece. So those were the key things I was going to mention. And just to conclude that in terms of timing, interestingly, the IFR haven't yet committed when they'll start applying this test. As I said a minute ago, they seem to be in a hurry. I could well believe, I think the timing is lined up. It could be possible they could even start acting before the end of the year. We're certainly seeing some stories about some clubs and their owners in the news. Query, is that something IFR has its eye on? I don't know.
Well, they've definitely said in their consultation that they're looking at autumn, aren't they, to be fully up and running in terms of fully equipped. So that'll be interesting to watch your space. Thank you for that. We've got a couple of questions, and if it's all right, Christopher and Mark, who asked the questions, I'll come on to those in a minute. Trevor, sorry you've been experiencing all these technical problems. Obviously, we've had Raphael talk about the sanctioning regime. We've had Trevor talk about David talk about the owners and officers tests. From your side, you've been involved at the board level. You've been a fan. Obviously, you are a fan. You saved the club in Bournemouth. What's your perspective on this? You're muted at the moment, just so you're aware. So there you go.
There you go. I'm muted.
There you go. Yeah.
It sounds like a lawyer's dream, doesn't it, Sean? I mean,
That's
Raphael and David are going to be busy for the next 100 years. Look, I'm the global head of sport and entertainment at Pinsent Masons, but I was a boring insurance litigator until 1997. I'm not saying all insurance litigators are boring, but in 1997, I decided as a Bournemouth fan to offer my help to the remaining two directors when the club went bust in the middle of a season. They did ask for my help. They said, why don't you go and raise the money to keep the club alive? In short, that's what I did. And in the end, the bank said, why don't you buy the club? I said, I haven't got any money. So they they lent me nearly £3 million to buy a football club, which I did as a fan's rescue. It put me at the heart of, well, we're in League One, sadly not in the Premier League at that time. We managed to build the stadium that we play in to this day. And the chairman of Gillingham, who had punched me at a game or stuck his finger up my nose, quite literally, a year or so later asked me if I would defend him in a case brought by his old manager, now my nemesis, Tony Pulis, because we ended up doing, I think it was 4 or 5 pieces of litigation involving him. That case, and then we sued Bristol City and we won that case. And then Steve Lansdowne asked me if I would help him with Bristol City, and here we are 25 years ago, and we sold Bristol City Women last week for Steve to Mercury 13. So my perspective, I am a lawyer, but given you've heard eloquently from Raphael and David, I wanted to just throw some reality into this, not saying that my learned colleagues were not in the real world, but if you took a jaundiced view, you'd say it sounded like fantasy football. As kids, I'm sure many of us on this call like playing Subutio, if you remember that, or as we do fan football and pick your winning team. Football has, one way or another, got by over the last 28 years since I've been involved. We've had a football task force or two. We've had supporters direct. We've had a wave of insolvencies. We've had financial crisis in 2008. We have always, David mentioned, there's owners in the press. There's always owners in the press. So why a regulator? And what does that tell us about what we should be aware of and what we should be thinking of? And I think if you are an owner or you are an investor thinking about coming into a game, or if you are an executive at a club, or if you're a sponsor or you're a funder, unfortunately, this is going to impact you because it's going to call into question your business decisions and how you go about running your business. Because as Raphael has very eloquently put it, this is a statutory body that has statutory powers that, like it or not, however football thinks it can run itself, is going to get busy. And it will get busy with football. In my view, firstly, not on the areas that have been mentioned already, I think its first and foremost task will be to try to redistribute wealth within the game. That I have heard from various stakeholders, and I think that there is a knock-on effect across football, and we will be looking very carefully at what the regulator is going to try to do to break this impasse, so to speak, between the English Football League and the Premier League. And there's been various negotiations going on between those bodies which haven't resulted in a conclusion. And this is a political hot potato. Arguably, as David has mentioned, there's football clubs in every constituency, and those clubs have fans, and those fans are invariably voters, and those voters will put pressure on the politicians. And we've seen that. I mean, we work from half the Premier League in giving them advice on various issues, but we also work with a lot of clubs in League One, League Two, and below that level, all of which have very important places in their communities. We worked on Bury and the Bury rescue and the Bury restructuring that some of you may be aware of. Hugely important. If a football club's going bust, it will get the attention of its MP. So to that end, Labour cannot afford, or the government, whoever they are, cannot afford for this to fail. You can question whether politicians are the right people to be creating a body to oversee football. You can question their resources. Sorry, go on, Sean.
That's right. From your side then, obviously the counter argument. So again, like beautiful sport generally is beautifully dysfunctional, right? But as you say, it kind of works, but there are consequences to it not working, as you described with Bury, and in your case in Bournemouth. So from your side though, are you basically saying that the people involved in the commercial aspects of sport should just be mindful of this, and particularly during this consultation, what the impact has been? Or are you saying that you think that level of scrutiny may cause a friction in the market that may be an unintended consequence?
Well, let's just take a hypothetical. Sean Cottrell to be HR director of, I don't know, Nottingham Forest. Nottingham Forest.
Accept your offer.
About
not in football. Commercial director, I'll take that.
What validates a regulator in having a look at your application and determining whether you are suitable for the job? Because the regulator has already been highlighted, is going to get involved. Interestingly, not in the appointment of a manager. Now that really would be fantasy football. Not in the appointment, not in the appointment of a sporting director, as far as I understand it, but commercial director, CEO, CFO, COO. It will be interesting to see what objective tests it can apply, because that hasn't happened before in football. Let's talk about the owner of Sheffield Wednesday. I don't know him personally. He's getting a lot of flack in the press. When he walked up to buy Sheffield Wednesday and he had £250 million in the bank, was he a rogue owner? Arguably not. Is Mel Morris, who oversaw Derby County, who went into administration, we dealt with the insolvency of Derby. Was Mel Morris a rogue owner because the club ended up in insolvency? Are the Glazers rogue owners? Now, I'm sure some fans would say, yes, sir, of course they are. Others would say they're responsible business people that run their club according to priorities of business. So I think what's going to be interesting is to see the way in which the regulator adapts what the Football League and the Premier League have already been doing for years. It's not as if the Football League and Premier League haven't got tests. They haven't got ways of assessing. But the regulator, and if you don't mind just going on to two other points, the regulator is going to identify rogue owners. Now, my suspicion is those rogue owners, so to speak, will be those who are identified down the line. Now, which of the clubs that have been associated with this of late? Reading, for example, a lot of hostility towards the previous owner. Sheffield Wednesday, we've mentioned. Are they rogue owners because they run out of cash? What is it about them that causes this ire? I mean, the fans throwing their tennis balls on the pitch at Reading because they're upset at the direction of travel. They're upset the team isn't winning. It's going to be a really interesting dilemma for where the regulator steps in, because not only can he remove people, he can step in and run a club. And again, that's fascinating, because having run a football club, I remember my manager once, he said, I've got to sign this player. I'm going to give him a 3.5-year contract. We signed him. That was on a Thursday. We played Bristol City, funnily enough, away on a Saturday, and we lost 3-0. By the Monday, the manager was telling me we had to get rid of this player. And I said, we've just given him a 3.5-year contract. What I found out was the player had actually objected to the manager's team talk at half time. So the manager decided he must be a bad one because he disagreed with him. But I've got a 3.5-year liability on that contract. COVID. Now, other factors that can come in. Relegation. No team wants to be relegated. So ultimately, what's the regulator going to do if they come in and decide to run a team? Because what's going to happen? What's going to happen to the losses? What's going to happen to the liabilities? So I think that is something, Sean, that ultimately clubs are going to need to think very carefully about how they manage the day-to-day operations, how they put their business plans forward, and owners and funders are going to have to think very carefully about the state of the game. Because the last point I'll make on this is there's been a lot of talk about providing economic buffers. Anybody on this call that's involved at a football club, and we do so much buying and selling. I say I sold Bristol City Women last week. We've probably got 15, 20 transactions on the go at the moment. There's huge interest. But if a buyer is being told that they have to put 1-2 years' money in the bank, as club chairman said to David and I yesterday, my owners would just hand you the keys and walk away. So there will be effects. And I think that the other risk we have here is mission creep. And what are the boundaries? And I think that there's a lot of definition yet to come. And that's where everybody on this webinar can really play a part. It's where Raphael, David, and myself are doing a lot of work at the moment, which is working with clubs on how you can be ready for the regulator, because that is important, because there is a chance to influence.
Yeah, and I think that Trevor, I think one, that's I always love your passion and enthusiasm, like as in you're I said I always love this because you're first and foremost, I know you're a business person, but you're also a football fan as such. But the thing that I think is interesting is that, again, I think from DCMS's perspective, from my own experience anyway, talking to people at DCMS, talking to people at the regulator, that there is an intention, that they're well aware of the fact that they're currently anyway, at least, that they want to protect the good elements of the game, right? They understand that it's a thriving sector, and obviously the issues around heritage and so forth. So I do think there's an awareness that they don't want to have lots of regulatory creep, but inevitably with all these things that changes, as Raphael and David said, when politics gets involved, all bets are off at the moment. And we've got a couple of questions from the floor, or partly on this. So Christopher Flanagan asks, my experience of the S166, you're a proper lawyer, Christopher, thank you, FSMA appointments is that they are incredibly onerous and disruptive. How do you think football clubs which run much leaner might cope with the analogous process? How can they prepare themselves?
So I can say something about that. Section 166 FSMA is the provision.
I said it wrong, didn't I? FSMA, sorry.
People say it different ways. But it's the provision providing for the appointment of a skilled person by the financial regulator. And I think Christopher's sort of drawing the parallel between the appointment of a skilled person in that context and the appointment of an expert reporter or a skilled person at the investigatory or sanction stage under the Football Governance Act. And I think what can clubs do to prepare for that? I mean, I'm not sure there is right now. I think part of what clubs need to be doing is communicating to the regulator the very different position in which they stand from the types of regulated entities in respect of those in which those powers have historically been used. I mean, let's bear in mind the IFR has its own statutory duties under the Act to act proportionately. And the point that you make about clubs running much leaner, that is relevant and ought to be taken into account both practically and very possibly as a matter of legal obligation by the regulator when it's thinking about how it's exercising those information gathering powers. And I think that's exactly the kind of issue that when the IFR is sort of going to market right now saying, well, because this is part of its enforcement consultation, it's saying, well, here's how we're proposing to exercise our investigatory powers. What do you reckon to this guidance? I think that's the kind of thing to be raising with the IFR, saying actually you may not have the visibility of what that looks like in terms of resourcing and practicality for us. If your investigation looks like that, rather than a list of questions in an email, if you're doing an information notice, or, as I was talking about before, something much more informal, maybe more akin to what clubs are used to by way of information gathering, not necessarily statutory information notice, but more informal dialogue. And that's all being shaped right now.
And so Trevor, I've muted you just because there's some background noise. So let me just bring you back in. Sorry, Trevor.
Well, Sean, I was just going to add very quickly. I mean, Raphael made some really good points there, and I think it is worth emphasising that one of the IFR's duties in the Act, it does need to take account of the different circumstances, different clubs. So it's going to expect a lot more from a Big Six Premier League club than it is from a National League club. But also, there's also that real world factor I mentioned. It has got limited resources, so it's going to prioritise where it targets its energies as well, I think.
But you've got two things here, David. You've got the initial pre-appointment of an owner or a director or an executive, and then you've got, as Raphael's talked about, the investigatory side. And on the pre, they're going to be standardized forms, standardized processes and stuff. And I do agree. I think the regulator's got limited resource. He ought to pick and choose, and clubs ought to be able to influence the degree to which it investigates. But what's the difference between a CEO going into a League One club, CEO going into a Premier League club? Surely you've got however you're going to evaluate it. And goodness knows how the regulator will, to be honest, because ultimately there are already tests on probity. In terms of it's the intervention that I'd be more concerned about how that's going to be shaped and how that's going to interlink with, if you happen to be a club with a European license under UEFA, how you're complying with UEFA, you're complying with your domestic league, you've got the FA, and now you've got the regulator. So you've got four different sets. I mean, that it is going to swamp. I was speaking to the CEO of a EFL club, let's not say which league they were in, yesterday, and he was saying, I've been told I need to cut my loss from this to this, and I need to make tough decisions. So you've got clubs that really have got scant resource. And it's going to be fascinating to see what the regulator's going to do, because if I'm right and he's looking at redistribution, it's what's going to come with that in terms of checks and balances. And as you know, if you look across football, various measures are being taken to try to look at cost protection. But equally, I know there's a considered view that really it's the top six of the Premier League ain't going to be touched by this. It's going to be the Championship and League One sides that they're the ones where the stories tend to come from, where the problems have tended to arise with cash flow, where the variables between the leagues start to really differentiate. And that is where I think we'll probably see the most activity. And I think it's, there's a meeting on Wednesday next week in Manchester where all the clubs are getting together with the regulator. I would really push for very clear definition of what's going to happen and a less burdensome approach.
Well, I think it's interesting though, because if you look at, say, what we witness across all the EFL clubs we work with and Premier League clubs, is that if you looked at where everyone's so focused on obviously where it matters in terms of like where you're having the biggest impact, which is obviously on-field performance, typically, that some of the staff are working very, very hard, already doing quite like broad jobs. You'll have the head of football administration now, club secretary, and they'll do a vast job already. And so maybe there might be some positive outcomes from this in terms of they might look at it and go, actually, maybe we do need to have someone to look at, to actually be responsible for compliance. And, maybe there are some knock-on benefits for that.
What I would say is when I was chairman and I ended up being a divisional director of the Football League, if we went to a vote at the Football League annual general meeting, 3 divisions: Championship, League One, League Two. Invariably, the Championship would all vote one way, League One, League Two would vote the other way. It wouldn't make the big difference because Championship have 82% of the vote or something like that. And that would be that. And you're right, Sean. A lot of responses are determined by what league you are in at any given time. This is an opportunity for football to really help shape. And to a degree, in terms of the regulator, a lot of our clients, our clubs who we work with, welcome the regulator, because it does take that problem away from the Football League. And we've seen this division of responsibilities between commerciality and regulatory. We've seen this with the FA and the changes in shape and form, that this takes a problem away, because you can point to the regulator and say, well, we've got an independent body and they are the ones taking action. But, you know, as everybody in football knows, Trevor Birch in the Football League, Richard Masters in the Premier League, it's not like they're sitting back doing nothing at the moment. They are working incredibly hard that nobody wants rogue owners. Nobody wants the game brought into disrepute. Nobody wants people ending up with no money and clubs going insolvent.
Absolutely. Right. We had some technical issues to begin with. So for those attending, if we could just take these 2 questions, then we'll try to draw it to a close. Could appreciate everyone's time and everyone's busy. So do you agree? So Mark O'Neill asked, do you agree with the regulator's proposed more flexible approach in assessing the fitness and integrity of potential owners and directors? By that I mean, does the guidance appear to say that there will be no automatically disqualification criteria, such as being subject to sanctions or prohibited from entering the UK? David?
Yeah,
maybe?
well, I'm happy to start off on that. I mean, yeah, it's quite clear the Act envisages a discretionary approach to the IFR's embracing this. I think that's sensible. It wants to give itself that discretion to look at all the facts of each individual case, rather than have those automatic triggers that someone is barred from being an owner because of one particular event. So I think that's a fairly sensible way. It allows things to be dealt with on a case-by-case basis.
Brilliant. Thank you. So someone just said if the webinar froze at some point. So we are going to put the recording up just on our YouTube channel if you want to watch it back. So it'll be helpful to people. Obviously, it's going to be out of date in a few weeks' time. That's all these things move. So for a short period of time, hopefully people will find it useful for context. Then we had, which I think is a really interesting illustration. Some anonymous attendee says reform is slowly creeping up the polls and is seen as Labour's main threat in the upcoming elections. Reform have demanded that the government leaves football alone. How do you see this impacting the regulator, if at all?
I'm happy to take that one as well.
Yeah,
Trevor's
go. Trevor's. I'm just unmuting.
We may disagree, David. Ultimately, at the end of the day, things have a shelf life. As I mentioned earlier, I've lived through numerous reviews of the way football is governed and operated. And at this present moment in time, it's like VAT on private schools or immigration policies. These are the sort of things people will shout about because they're populist. What happens in due course, the regulator can always be removed. But ultimately, at the heart of it, football is a national game, one of many, arouses great passion, as Sean's pointed out, with myself being a Bournemouth fan. And ultimately, people care, fans care, communities care. And so there will always be some shape or form of regulation, whether it's this regulator, who knows?
What do you think, David?
Yeah, I mean, I think that's right. The point I'd emphasise is that one I made earlier, that the regulator, it's got a job to do. It's set out in law what it needs to do, but it's got one foot in the world of politics, and it is going to be doing everything it can over the next 3 to 4 years before the next general election to show and prove that it is a success as a regulator. It will, it will want to continue doing its job after an election. If it has a nightmare of the next 3 or 4 years and this consensus builds that it's doing a terrible job, that it's destroying English football, then yeah, sure, a new incoming government would turn it over.
Knowing if it's anything like how the press treat the players, that might be the narrative.
And I'm sure Raphael's going to come in, but that is the thing, because ultimately, in a hypothetical world where the regulator says, well, Mr. Chansiri, you haven't been putting money into Sheffield Wednesday, we don't like what's going on. Now, if you believe the media, let's stick in what the media is saying, there are bidders out there for Sheffield Wednesday. Is the regulator going to make a decision to kick out the current owner, tell him he's got to sell, which is what we've seen, for example, in baseball and other sports in the States. So it's not alien to the industry. Negotiate with a buyer, determine which of the bidders, well, I don't know, we might have an auction, but which of the current bidders they should sell to, set the price, set the terms, determine how the proceeds are used. I imagine Raphael's going to tell me that will give rise to oodles of litigation.
That's why he's smiling.
So I'm not going to say anything about Sheffield Wednesday, and I don't think I'm.
Well, no, I'm just talking hypothetically about what's in the media, rather than any, I don't know what the actual situation is.
But I think what I would say is that I absolutely agree that the regulator is going to be affected by the political media and climate. And I think it's going to be affected by that in a couple of different ways, because I don't think really on proper analysis it would be appropriate or lawful for a public body to come along and say, well, this is what the public wants, or this is where the papers are, this is where the political conversation is, and so this is what we're going to do. But at the same time, the regulator itself has various obligations to take into account the position of central government and the Secretary of State, as expressed in guidance, state of the game report, regulatory principles, all of that sort of thing. And so the political context, insofar as it's shaping central government, is trickling down to the regulator as well. And then the regulator is also, as David was pointing out earlier, by virtue of being a public body, although it's independent from government, it is more widely accountable. It's accountable to Parliament. We'll probably be seeing, people from the regulator getting called before select committees and answering questions in public. And so, absolutely, I think that where that wider political conversation is about, as you put it, should football be left alone? You're not going to see that at the top of a regulatory decision, but that conversation is going to be there under the surface.
And again, this is all the more reason why, and I know from speaking to people there that this intention to have really good dialogue with the clubs, hence why they're doing this consultation, is so important, right? Because if they have that communication, and I was thinking about the question that was posed about what can football clubs do to prepare, and it seems make sure you're ready to have and be available to have that communication is going to be one surefire way, at least, that you've had your opportunity to voice your concerns. I'm very conscious of time. So, Trevor, do you want to come in? Sorry.
I was just going to say, Sean, and why stop at football? What about rugby?
That's a whole nother webinar.
What about cricket?
You bring that up right now.
I was just setting it up, Sean, for you. But it is a moot point, because what is the purpose of the regulator? Why are they being created? What ill are they looking to cure? And why do they think they do it better? I think good governance is important, clearly. Having the right regulatory framework is vitally important. Being able to say, well, there's the regulator and we get on and do the rest, I agree, is important. But I wonder where we might end up a decade or two from now, and whether we see this across other sports.
Well, I've been talking about this for years, as if like a broken record. I say, not the sharpest tool in the toolbox, as they say, but the one thing I've always said is that when a market gets to a certain size, government want to intervene, and when there's capital flows, there's all the investment in the 100. It brings all these other associated issues with it. So I think around the world we can probably expect more of this.
And I think is a really important factor. The only last thing I would say is sport. Second or third largest sector in the world, sport and entertainment, in terms of value. The value to England and Great Britain of sport, particularly football, is huge.
Yeah.
And we have a big office in Riyadh. We do a lot of work out in the Middle East and in the USA. The interest is unwavering in what we do here. So I think there are big economic considerations in how this goes forward.
Yeah, and I think that was identified in the white paper, wasn't it? The significance of it. But look, thank you all very much, Raphael, David, Trevor. As I said, those people that know law in sport and know what we do try to help people understand, you know, what's going on in the sector, so you can become better prepared, engage more, be more informed, get access to accurate information. If you liked it, if you took value from it, please do share it with other people. We really appreciate it. Other than that, I hope you have a great day. There's going to be a lot to watch. Really looking forward to seeing what the outcome from the consultation is next week. As I said, we'll put it on our YouTube channel so people can get access to it. Hopefully they'll find it useful, and we'll put it on the website as well. Other than that, Raphael, David, Trevor, thank you all very much, and sorry for the technical issues that we had. Thank you. Bye.